Welcome, everyone. I'm going to give everybody just a minute or two to cycle in, and then we will get started. Okay, welcome to the webinar, everyone. Before I hand it over to our host and presenter, a few quick housekeeping items. This webinar will be recorded, and you'll receive the recording link, slides, and an asset protection checklist emailed to you. So be on the lookout for all of that in your inbox later today. This webinar will run 50 minutes with 10 minutes Q&A at the end. If you have a question for our presenter, please put it in the Q&A box located in your Zoom toolbar. To find your Zoom toolbar, just hover your mouse over the top or bottom of your screen and it'll pop up. Now I'll hand it over to Adam to get us started.
All right. Good morning, everyone. Welcome to the Asset Protection for Business and Investment Property Owners. How to protect your hard-earned assets due to loss from lawsuits. Thank you so much for joining us today. We're really glad to have you here. I'm Adam Odom and a partner here at LSL CPAs. I'm really excited about this topic and I'm looking forward to Brent sharing his knowledge with us. Now I'd like to introduce our presenter. Brent Honea is an attorney with Barth Calderon Attorneys. He has spent over 20 years in the investment industry, helping families and business owners properly plan for their finances. He enjoys communicating complex subjects of estate planning and asset protection in a way that his clients can understand and appreciate, so that they can go on to manage their lives with confidence and security. Brent strives to build lifelong relationships with his clients to ensure their plans are up to date and where they need to be implemented. Take it away, Brent.
All right, thank you, Adam. Appreciate the introduction. I appreciate the time to talk to everybody today. So good morning, everybody. So we've got an exciting topic, I think, for you today to talk about. As Adam had mentioned, I'm an attorney. My focus areas are asset protection, literally just helping people to make sure they're properly set up and protected in the event of a lawsuit so that they don't lose those important assets they've worked their lifetime to accumulate, as well as estate planning to protect their heirs and their loved ones, avoid probate, and protect against things like future divorce loss and lawsuit loss. So today, as far as the game plan goes, we're going to talk about a variety of areas. Agenda-wise, some of the areas we're going to make sure we talk about would be on the slide here: properly structuring your LLC, making sure your LLCs are properly structured to make sure that if you do have a problem or get sued, that they protect against both inside-out and outside-in liabilities, and we'll talk about what that means. Second, we're going to talk about how to best safeguard your investment property, your holdings, your stocks, bonds, cash, and personal assets, both that are inside the business that you may have, as well as your personal assets outside the business against loss due to lawsuits. We're going to talk about ways to avoid losing more in a lawsuit due to community property issues, and why community property, as we have here in California, may not be the best way to hold title to all of your assets. And in addition to that, we're going to be talking about ways to structure your family trust. Many of us have family trusts, and how to protect our heirs from potential future divorce, lawsuit situations, and create what we call a lifetime trust. So we're going to touch on those issues. And many more. So in terms of today, the issue is so what? Why is this important to all of us? Why do we care about this now? As an asset protection firm, we're one of the top firms in the country that help clients in this area. We feel that asset protection is critical today. It's always been a bit of a big deal, but we see literally an explosion happening in lawsuits right now, and it can mean the difference between keeping the family residence or losing the family residence, keeping that business or businesses or that rental property portfolio that you have, or losing it all in a lawsuit. So it's extremely important to know what the rules are of asset protection. Right now, due to the COVID and shutdown and such, we're seeing a big explosion in the area of lawsuits. People who are now returning to work or choose not to return to work, tenants who have a variety of issues that are going on with landlords and such. We think we're at the beginning stage of that. So the time of talking to somebody about being protected is extremely important. To it's all about timing. So to get that going is important. In a nutshell, asset protection, what is it? It's really taking advantage of and using the legal exemptions that we have for our various assets that we have out there today, making sure that we're as protected as we can legally, using various legal entities such as LLCs, special types of trusts, reorganizations, and so forth, to make sure that the assets that we do have are really difficult for somebody to take from us if we get sued. Some stats for you in terms of why this is important. Somewhere in the neighborhood of 80% of the world's lawyers are right here in the US. 90% of the world's lawsuits are here in the US. Roughly 3.7% of US GDP is generated from lawsuits and their attendant costs, which is horrible. Why? Why is this happening? Why do we have this going on in our country? Why is there such a litigation, explosion? Well, number of reasons, but primarily we have a system that's built for that. We have contingency fee law system so that people can bring a lawsuit against anybody that they feel like for pretty much any reason, and as long as they have an attorney who will pick up that case on a contingency basis, there's really no cost for them to do that. So we have that kind of a setup, but I think also we have a change in mindset here that I think if you look, you go back in time and think of when we were growing up, you think of those people that have worked hard and built a business and built what they have, and you look at them with respect and say, these people worked hard all of their life to build what they have. And I think now we're seeing a mindset change where you see a lot of folks out there who think that, if they've done that, maybe they did something a little bit crooked or wrong. And I think I want to settle the score with them. And how do I do that? And so with all that in mind, we have a lot of people out there who just like to sue. So the main point I want to get across to everyone today on this webinar is that it's best to be proactive in this area, right? To make sure you've done all the planning you can, you understand how this works, and you don't find yourself in a bad situation and then trying to protect things after the fact. It doesn't work really well. So quick disclaimer, this talk I'm about to give here usually takes a couple hours. So we're gonna talk fast. We're gonna get through as much of it as we can. And if you find that you still have questions, the specific issues that you want to get into, we're not getting into for your personal situation, I'm here for you. It's a complimentary consultation to talk to LSL to get a hold of me. Happy to help. So what we're gonna do here next is I wanna lay out some basic ground rules of asset protection. So that we have some different definitional items out of the way. And then we'll spend the majority of our time with a hypothetical illustration. I think that's the best way to learn, the topic. So let's start off with some ground rules. I've got 3 ground rules for everybody today. The first being that this issue of asset protection works really well. Everybody's allowed to do it, but it needs to happen before a problem, right? Before the lawsuit happens, before the issue has come up, we do our planning when the coast is clear. If we wait till after the problem happens, it's the equivalent to, your house catching on fire and you go to the insurance agent and tell them that you want to go buy some fire insurance. It doesn't work very well. So I meet clients in one of 2 ways, either a very, easy conversation where we're talking about their assets. How do we take them from vulnerable to protected? What are the most efficient and inexpensive ways to do that? Or what we call hair on fire clients, where they come in, something's just happened. It's bad. And they come in wild-eyed and they're looking for, it's like crazy talk. Can I divorce my wife and give all of my money to her? Does that work? Can I give it to my brother-in-law? Can I move it offshore? All of these things after the fact are speed bumps. At the end of the day, whatever you do after the fact planning is not super effective. So better to do these things before there's a problem. Second ground rule. Many of us have a revocable living trust, and all of us should have a revocable living trust at some, at this point in life. If we don't, see me. We're happy to set up a great, estate plan for you. But one thing to know about it is if you have a revocable living trust, right? The type of trust that you can make changes to, it's revocable, you can amend it. Many people think, and I know this because they come in and tell me that they think that there's some form of magical protection that goes along with that, so that if they get sued and their house is in the revocable trust, that's going to protect something. I'm here to tell you that's a misperception. It doesn't help. If you can make changes to your trust, you're the one in charge. There's no asset protection there at all. It'll help avoid probate, but that's about it. So that's the second ground rule. Third, insurance. Here I'm talking about property casualty insurance. So property casualty insurance, we're basically talking about, things like umbrella insurance and business insurance, things to protect in case there's a problem, right? And I think the issue here is that many folks will look at what we're about to talk about and say, well, Brent, why don't I just go get a whole bunch of insurance and take care of the problem? And to that, we would say insurance is great. You should have insurance as a component of your asset protection plan to protect, your business, to protect your personal assets. If you have real estate, to protect your real estate portfolio. However, understand it's not the end all be all. And the problem here is that through really good marketing, we've been conditioned to think that insurance takes care of, a lot of things. You think of the guy walking down the street on the commercial, and then there's some towers on both sides of the street, and they're throwing, bowling balls off, and pianos start falling out of the sky, and he pulls out this big red umbrella, and pretty much everything bounces off of it. And that sounds great. That'd be wonderful if it worked that way, but we have to realize that insurance companies are for-profit businesses, right? And so that being the case, when we look at a policy, we've got a page of what's covered, followed by 30 to 40 pages of what's not covered, exclusion areas. And in addition to that, the insurance policy will go up to whatever the limit is. And if we have a lawsuit judgment that's more than that limit, in many cases, lawyers won't stop there. They'll come after your house and everything else you have. So that's when all of this becomes really important really fast. So insurance is good, not the end all be all for everybody. A couple more definitional items here. I want to talk about inside out versus outside in liability. And what does that mean? So let's start with inside out liability. That's the one I think we're all familiar with. If we start a business, right? We start a burger joint, and we set it up and we put it in our name, or we have a partner and we're set up as a partnership. And then all of a sudden there's a problem at the business and we get sued in the business. If we're set up that way, our personal assets are exposed, and that lawsuit that happens in the business can come after our house and our other properties and our money in the bank. That's an example of a lawsuit that starts inside and goes out, right? Inside out liability. And that's why we set up things like corporations and LLCs. Outside in is different, right? So outside in liability looks like this. We have a business, we have properties, we have other assets, and then one day a car crash happens, right? Lawsuit judgment comes out, and the insurance covers maybe part of the issue, but we find that we lose our rental properties. Maybe we lose our business, that burger joint, because it's not properly protected. And so our other assets that are totally not part of that accident or that issue get caught in the way. It kind of spreads like a virus back at those things. That's outside liability, outside in liability. And what we find is that people, in many cases, that's a blind spot. And it's the way that many businesses are lost, frankly. And so we want to talk about ways to firm that up and not let that happen to you or I. Second definitional item is what's a properly structured LLC? So here, being the nature of what we do, we get to talk to a lot of people about what they have, analyze their current structures. Limited liability companies we feel are great to protect things. They're your good first line of defense. We should be using them for a lot of things. But there's a difference between a properly structured LLC and a not properly structured LLC. And here's what I mean by that. When I talk about LLCs in the example we're going to talk about, what I'm talking about is an LLC that is formed in a state that's protective of you, the person forming it, right? So whether it's for your business or your rental property or what have you, we don't want to pick California to be the place where we form, right? So we want to pick a state. In our mind, we typically are looking at states like Nevada, Wyoming, Delaware. These are states with better asset protection. We're allowed to form there. We can pick any state we want to. And we want to argue that that's the state that governs the case at hand, should that ever come up for you. So we would want to be set up in another state. We're registered in California if that's where the business is, or the rental property and so forth. And in addition to that, we want to make sure that the LLC, if we can, is not a single member LLC. So a lot of times I get to see LLCs where somebody's formed the LLC to LegalZoom, or at a firm that maybe doesn't do a lot of asset protection, and they feel very comfortable and confident. They've got their LLC. All they've got is paper, right? So if the LLC is 100% owner and it's set up in California, we need to understand that the way LLCs came about was through partnership law. You had partners who wanted to form an entity to protect their stuff. They didn't want to go through the formality and the hoopla of creating a corporation. So they created an LLC, and it was born out of partnership law. Down the line here, as we've moved on, many people said, hey, why don't we just do that for ourselves? Let's create our own LLCs. And then you're allowed to do that. But understand that in many states, the single member LLC, just one party, the laws there don't protect very well. And in many cases, they can be pierced both coming out and going in. So a properly structured LLC, to the degree we can, we want to have other members, even if it's a small amount, 1%, preferably 2% or more, where we have either our kids through a kids trust, maybe they're another member, another partner, spouse, things like that. We really beef up the protection of that LLC when we create a multi-member LLC and we move it out of state. Also important, I find a lot of LLCs where there's no operating agreement that was set up, or we're specifically spelling out how this thing works and how it's got those asset protection provisions in there. You need a good law firm to create that for you, so we can help with those sorts of issues. So properly structured LLC is important. So let's transition here. So with the time we have left, what I want to do is get into this slide that I think we have on the screen here. And what we have is a fictional couple. I think this is the best way to learn this kind of material. So we've got a happy family here. We've got John and Jane Smith. They've got 2 little kids. They live here in Orange County. John owns a successful contractor business that he's built up over time. And that business is 100% his. It's a California S corporation, like many construction companies are. That's in his name, does really well. Value of the company is about $1 million. Okay. And we'll go through as many of these different items as we can on this talk. Jane is a mom. She's a homemaker. She is taking care of the kids and all that goes with it, and very busy doing that. But in addition to that, she has a pretty successful IT consulting business that she set up, and she has set that up as a single member LLC. So if you see on the slide, single member LLC, that's Jane's business. We're going to value that business as about $100,000, and it's a California LLC. That's where we're set up. In terms of insurance, they've done some asset protection planning, and they've got an umbrella policy that maxes out at about $1 million to cover things. But when we look at their portfolio, if we add everything up, that portfolio net worth comes out at about $7.5 million. So they've done really well between their businesses, their home, their properties, and so forth. So $7.5 million is their net worth. Okay, all is good until one day. One day, Jane is driving the kids around from one activity to another activity, busy as we all are. At the same time, busy with work, on the phone, trying to make sure that her clients are happy. And as she's going down the 55, she makes, frankly, not a great lane change, right? She's on the phone trying to take care of too many things at once. And in that situation, doesn't notice that there's a motorcyclist who's coming up behind her, splitting the lanes, as we often see. And she changes lanes right into him. He goes down, and unfortunately, he passes on in that accident. So in that moment, everyone's life changes. Horrible, horrible situation for anybody to go through. For our purposes today, we're going to talk about what happens when the dust settles after all this stuff. What does the family keep? What do they lose in the lawsuit that follows? The questions start coming fairly quickly. Are we going to get sued? Oh my God, could we lose our house? Could we lose our vacation cabin that we inherited? Our money in the bank? What do we lose? What do we keep? So our exercise now is to figure out in the situation what's going to happen. So let's assume that we go through the lawsuit process. The family sues, and they were awarded $7 million in that judgment by a jury, and that's what they get. So we've got a $7 million judgment in hand to go after these various assets of the Smiths. First, we look at the insurance. Let's assume the insurance policy here covers, does its job, pays the $1 million settlement. First question is, do we think that they'll stop there? Are most lawyers that do this, are they good guys? Do they want to stop there at the million? They got a $7 million judgment in hand for their clients. They're going to stop. In most cases like this, no, they would not stop. They will go after assets if those assets are vulnerable and if they're not protected and they're easy pickings. Okay, so that's the scenario. Let's start with their personal residence. Their personal residence is worth, let's say it's worth $1 million. It's currently titled in their revocable family trust that they set up to take care of things in case they get, if they're incapacitated or they pass on at some point. So $1 million house in the trust. Now, question to the group here, if we can get that out. What do we think? Do we think that in this situation, they will lose the family home or keep the family home? So Jill, I think we have a poll question here. Do we think they're going to keep it or are they going to lose it? So let's go ahead and answer that one, and we'll come back and see what you all think on that. And let me tell you what happens in the situation for the sake of time. The house, there's some good news and there's some bad news. Let's start with, oh, here we go. So good stuff here. So we got roughly a 50-50 here. We think about half, we're going to lose it, half we're going to keep it. And so the issue here is we got $1 million house. First we start with, is there anything protecting the house under the law, right? So we start with homestead rules, or what are the homestead rules like in the state of California? And the state of California, what we have is a scenario that's different from other states, right? Every state is different. If this house had been in Texas, had the Smiths lived in Florida, 100% homestead, we wouldn't even be talking about it. They're not going to lose their house to this lawsuit. Similar to, the O.J. Simpson's, civil suit where he lost, but he didn't lose his Florida home. California works like this. Up until last year, for the longest time, it was a really bleak situation. So the Smiths would have roughly $100,000 homestead protection. The house would get foreclosed on, and they would have to be paid $100,000 to go buy a new home. Bad. That got increased, and now in 2022, in this scenario, we've got roughly $300,000, well, not roughly, we've got $300,000 to $600,000 of homestead protection, depending upon the median sales price of the zip code that your home is in. So in their home in Orange County, we're going to be at the top level of that. They're going to get $600,000 worth of homestead protection, which means that yes, they'll lose their house, they'll lose the $400,000 of equity in the home. So Joe, we can go ahead and put an X through that one. And in that case, the good news is they would still get the $600,000 credit back, so they could go back and buy a new place in that scenario. So we have better homestead protection rules now than we used to. What that means for us today is if we have a home and we do what a lot of people do, where we work really hard and pay that thing off, if the value has gotten much over that exemption level, we might want to do some special planning to protect the home. So for the sake of the talk today, I can't get too far into what those sorts of items are, but suffice to say, we can do things like a residential privacy shield trust, right? We create a type of a land trust. We make the home difficult to get to. We have various other types of trusts we can use for the family home. We typically wouldn't want to create an LLC to protect the home, but there's a variety of tools we could use so that the outcome could be very different and at least be a motivation where people wouldn't just come right after the home. The Residential Privacy Shield Trust, to spend a moment on that, is valuable because it could help to, it also offers the value of privacy because it's the type of a land trust. So family home in this case, we're going to lose it. We could have done some planning to save it. Next, let's talk about, I don't forget it's all these, so I want to focus on the more important ones for you guys. So the business, so John's business, he's got a contracting business. It's that S Corp down at the bottom of the slide. And so remember, he's 100% owner of this California S Corp, successful business, and doing really well. First question is, this is a business that's owned in his name. The accident is Jane's accident. So do we think, and here's our next question, do we think that John, that we have the ability to lose that business that's in a corporation? Is that a possibility in this case? What do we think? Do we think we keep it? Or do we think we lose the business in this sort of a situation? So we have a couple issues here to think about. One, can this lawsuit jump from Jane to John? Two, if it can jump to John, it's in a corporation. Are we allowed to somehow do something with that? So in this case, we got some good answers here. We think 60% of the group thinks we keep the business, 41% thinks we lose it. Here's the reality of the law here in California. So good answers, but here's what we have. When we have our business and we own that business in a corporation, right? We own that, the form of ownership of that business that we have is company stock. And just like any stock, had John Smith owned, let's say he owns shares of Apple stock in his Fidelity account. It's stock. A stock is a stock. And if we lose a lawsuit, that stock is susceptible to being seized by a creditor who wins the lawsuit. They can seize your business, liquidate, you lose control, business is over. Bad outcome. It's not what we think. It's not why we would want to have a corporation. And that's one of the things we talk with clients about in terms of solutions and how do we fix that. The other issue is, how do we end up at John anyway? This is Jane's issue. John had nothing to do with it. let's talk a moment about community property. Community property is the law of the land here in California, as well as in minority estates, particularly here on the West Coast. From an asset protection standpoint, community property is crazy law, right? So we're not talking about a divorce situation. We're talking about if we get sued and we own our assets together, husband and wife, spouse and spouse, and we have everything in that big pool, it's all at risk. Whether it's John's problem, whether it's Jane's problem, it's everybody's problem. So that's how it jumps from Jane to John. So in this case, if the home is a community, or sorry, the business is a community property asset, as it was, if this business was formed after they got married, that business is lost. So a couple concepts. One, what if these folks had created a post-marital property agreement prior to this issue? And in that case, they created an agreement that says, hey, everything we have that we assign to this, it's no longer 100% community property. It's 50% John's separate property, 50% Jane's separate property. And we put that on the home and the vacation cabin and the S Corp and those sorts of things. We'd have a different outcome here, because what we're doing is we're saying that now a judgment creditor can come after, if it's Jane's issue, they can come after 50% of whatever that issue is, but they can't touch the other 50% owner. Okay, so they can't touch John for his 50%. We're limiting someone now to only being able to put a lien on the affected person's 50% of the home or the vacation cabin or the business in this case, which is really good. And it's easy to do. It's a very cheap thing to do. There's not a lot of negative side effects to that, but it's an option we want to talk about, and it's available, and it helps in those situations, especially when you have, like in my situation, you've got high risk spouse doing law, low risk spouse doing, taking care of the kids, that kind of thing. So it's one of the things we want to talk about as a post-marital. Second thing here is we typically don't like to keep, to the extent we can, when we see corporations, we want to at least talk about better protecting that so that business can never be lost from an outside-in attack like this, because that's what this is. This is an outside-in attack. The business didn't cause the lawsuit. It happened outside, and someone's trying to pull the business into it. If we have an LLC, the rules of the game are very different. If we had set up a properly structured LLC, if John had met with us prior to the accident, had talked about something called a statutory reorganization, what we would do is a procedure we do quite often, where we take that corporation, we change the formation from a corporation and literally reorganize that. It's the same business. The business doesn't change, but we now reorganize as an LLC. That LLC is registered, it's formed in Delaware. It's registered in California. The taxation, this is really important, the taxation does not change. From a tax standpoint, the LLC elects to be taxed as an S corporation, so it's not a tax negative. The change that needs to be made is whatever the business's name is, we can no longer hold it out and call it an Inc. anymore. It's now, ABC LLC, right? Not Inc. So we change it, we change the structure. Had John done that prior to this situation, he would never lose control of the business again. The laws related to LLCs would be one that we've limited now, the person who's seeking to come after the business, to what's called a charging order remedy. They can't seize the business, they can't foreclose on it and just take it. But what they can do is they can put a lien on profit distributions from that business, and that'll force a settlement, most likely, if they do that. And what'll happen is we'll settle for an amount out of court, and everybody will walk away. Much better result. We keep the business, we keep the income flowing. There's a payoff that happens, but we don't just lose our business that we've worked our life to build up. So that's what we call a statutory reorganization. That's one of the tools we use to protect a business. Next question. Let's say real quick while we're on this topic that John didn't form an S Corp, he formed a C Corp, right? In this case. And we're not going to do a poll on this one, but if I asked you, what do you think about that? The answer should be the same, right? So C Corp, S Corp, that's just a difference in the tax code, whether we're getting taxed as a C or an S. A corporation is a corporation and we own stock in the company. It's still vulnerable to an outside attack like this. So when I talk about this, and we're thinking about a car accident here, could be anything, right? Could be, the issue starts as a tenant who gets upset, or there's a mold issue in an apartment and they sue and they come after everything. Could be a fire that breaks out. Could be, somebody sues the business for a wage and hour lawsuit. Could be anything. Bottom line, in a situation like this, better to be an LLC than a corporation. Okay, so let's move off of that. Let's move into some of these other items to get you some additional learning here. So let's talk for a second about the vacation cabin. So here we have a vacation cabin that is in Lake Tahoe, on the shores of Lake Tahoe. So we've got, nothing great, nothing, outstanding. It's just a cabin. But we know that if it's in, on the shores of Lake Tahoe, we've got about a $2 million property. And in this case, let's presume that cabin was inherited by Jane. So Jane inherited that from her parents when they passed on, and it's in her name as her separate property at this point. So from a vacation cabin standpoint, I don't think we have a poll question on this one, do we, Joe? I don't think we do. So
no, we don't. Sorry. Nope.
Okay. Sorry about that. So in this case, the question would be, are we going to lose this cabin? Do we have any exemption? Is there anything that can help us here? And the answer to that, unfortunately, is no. We're going to cross that one off, because that one, there's no exemption here. Unlike at the home that you live in, there's no $600,000 anything, right? It's just, it can be used to satisfy the judgment here. And that vacation cabin gets lost, and the judgment gets used to satisfy the creditors who won in court. So we lose that cabin. The reason being is it's Jane's separate property. So there's no business of, is this John's? Is this community property? What is it? This is Jane's. Now, if we change the facts and say we had a post-marital property agreement here in place between the two of them, very different, because again, we've just limited it to the people in court to, rather than foreclosing on our property, to just putting a lien on Jane's half interest in that property, which is great. Now it's just a lien. We settle that thing. We make a much better deal for the Smiths, and they keep that cabin. In addition to that, let's talk for a moment about trust planning, because that's another topic that we want to get to, and it's really important. It's a big part of my practice here, and it's one of the things that we do a lot of trust review, and we look at what you have and say, hey, would you be concerned about things like this in the future? When you think of everything that you've built up and you leave that to your kids eventually, do we want to make sure that that property or the things that you've worked so hard for won't get lost in a, split in half in a divorce situation? Do we care that, we're leaving assets unprotected? Your kids have assets that they inherit from you, like this cabin. Do we care about potential loss like this? And most people would say, heck yeah, we do. We don't want to lose that after we're gone and can't have a say about it. So had the parents had the forethought to leave the assets to Jane, but in trust for her lifetime, rather than her direct asset, and this lawsuit happened, that trust would become irrevocable upon their death. So like we talked about a moment ago, a revocable trust wouldn't have done the parents any good, but in a situation like this, where Jane would have inherited the property in a properly structured trust, that house is off limits. It wouldn't have been lost. It would have been kept in that kind of a situation. So we want to create what's called a lifetime style trust. It's easy to do. And it's just about tweaking that trust that somebody has. So that's the story on the cabin. Let's talk a moment about life insurance. So the Smiths are starting to build some of their wealth through life insurance. They've got cash value life insurance. They're building things up. They've got about $100,000 worth of cash value in that. Under the current law, in terms of keeping or losing this policy, they're going to lose it. There is an exemption here that'll help a little bit. It's roughly, I think it's around $12,000. So they keep about $12,000 of the life insurance policy cash value, but the rest of it would be gone due to this lawsuit. So had they built up, 500,000 or $1 million, that's all fair game. What you can do with your life insurance policies, what you should do, is when you have cash value, it's a good idea to create what's called an ILIT. It's an irrevocable life insurance trust. And when those are set up properly, that becomes the owner of the policy. It does a couple things. Thing number one is, in a situation like this, it's now owned by an irrevocable trust. It's got asset protection qualities. The cash value is safe inside of that thing. So you get a big benefit from an asset protection standpoint here. But in addition to that, it also pulls it out of your state. So if it's set up properly, a lot of folks just want to have an ILIT for their life insurance because they don't want that lumped in with all of their other assets, so that when they die, we have a tax hungry government in place that wants to estate tax everything away. This is held separately, and it's not included in your estate for estate tax purposes. So a really good tool to talk about from a protection standpoint, as well as an estate planning standpoint. So it's kind of a 2-for-1 on that. What about the stocks, bonds, and cash? What do we have going on there? So we have, in this case for the Smiths, we have $1 million in Merrill Lynch account. It's held in title in a revocable living trust. I think you guys already know the answer. We've been doing this a little bit. If it's in the revocable living trust, that's gone. We're going to use that thing to satisfy the judgment. Had the Smiths created a simple, properly structured LLC prior to this problem, set it up in Wyoming, registered it in California, that becomes the title owner to the Merrill Lynch account, choose to tax it as a disregarded entity, so it just flows onto their tax return, that would have been a very different story. We would limit the judgment creditor here to just simply a charging order again. So in that case, typically we're gonna negotiate out of that one. We may lose nothing. We may lose a small amount, settle out of it, but we're not gonna lose the $1 million in stocks, bonds, and cash. So stocks, bonds, and cash LLCs, very effective. And that brings up another point. If we're holding a whole lot of cash in areas where we could get sued, right? For example, I see a lot of business owners where you hold, more than your working capital in your business. Much better to pull that out of the business, put that into your name personally, and create a stocks, bonds, and cash LLC that's separate from the business. There's no reason why your cash in the business should be vulnerable to, a lawsuit that starts in the business. It's easy to do. It's something we do quite a bit of. I'm going to skip 529 plan for now for the sake of time. Let's talk about retirement accounts. Many of us have built up over time retirement accounts, either at work or for self-employed, in our own IRAs, Roth IRAs, etc. Let's assume that the Smiths here had a 401k. Let's say that Jane had a 401k for $500,000. Let's also assume that from a prior employer that John has a $500,000 rollover IRA. And then lastly, under traditional IRA, we've got a $100,000 IRA in Jane's name that she built up and is building up over time in a Roth IRA in her name, just as a tax break for her business. Okay, so we've got those 3 different retirement plans. What are the rules for these things? So 401k, let's start with that. Here's some good news. I know there's not a lot of good news with some of this talk. Good news is your 401k, as long as it's a group plan, there's more than just Jane in it, more than just John in it. There's other distinct employees. It's exempt. It's federally exempt under what's called ERISA law. So you're not going to lose your 401k in this case. So this would be one where we would circle it and say, we're keeping that 401k. We're not going to lose it. When we get to the rollover IRA, similar. Different states treat this differently. California, generally, when we talk asset protection, is not a good place to be. But this is one of those cases where it's not a bad place to be, because the way California currently treats rollover IRAs is, to the extent we can trace back the funds and say, hey, this is a rollover IRA that came from a 401k type plan at some point. If that is the scenario, it's treated more or less as fruit of that same tree. So it's got the protection. Where we get a little bit different is the traditional IRA. When we have a traditional IRA, here's the issue. That's a plan set up just for Jane, right? And the way California treats those is there's no other parties in that plan. So it's not going to get any federal exemption. It's not covered under ERISA or covered under California state law. And in that scenario, the issue is we do what's called a means test. And the means test is basically this. Does John and Jane need that? Are they currently using that IRA for their day-to-day survival? In other words, are they retired and living off of the money? And it's based on the facts and circumstances, but there's a good chance that traditional IRA would not be as protected. So in terms of tools we can use for the retirement assets, if they're already exempt, nothing to do with them. They're already safe. We can put them in the column of it's safe, it's not vulnerable. But if we have a lot of assets, if we're self-employed that we're building that way and we want to protect them, we have various tools that we can use, creating IRA LLCs, self-directed IRAs that are put into LLCs and so forth, that we can talk about to better protect those kind of items. Let's talk now about down at the bottom of the slide, the single member LLC. Remember, that's Jane's business, her IT business that she was talking on the phone when this accident happened in the first place. It's an LLC in California. It's in her name. It's worth $100,000 and they get some income from it. So in this scenario, based on what we've talked about so far, we're going to keep it or we're going to lose it? Well, the answer here depends, and it depends upon the court and what they view with that single member LLC. If it's a California LLC, remember what we talked about earlier. If we had set up this LLC in another state, we would argue that the other state, let's say Wyoming, is the jurisdiction for this thing. If we're successful in that argument, Wyoming law is very clear that a single member LLC is just fine, right? So that we limit the person who's suing here, who's won in court, to what's called a charging order. They have a lien over profit distributions, but that's it. They don't get control. They don't get to seize the business, which is really good. Here, we don't have that. We have a California LLC. California is not a fan of the single member LLC, and oftentimes lets people pierce them and come after them anyway. So good chance that in this case, even though we're in an LLC, that we could lose Jane's business, and that's not good. If we move to the box next to it and say it was a multi-member LLC, let's say prior to this, that Jane had had the forethought to create this and properly structure it, set it up in Wyoming, have additional members in there. So that LLC includes her, but maybe there's a 2% interest in an irrevocable children's trust for the kids, another party with a small interest in there. At that point, we've put that LLC on steroids. For all intents and purposes, that's more or less a safe asset at this point. So there's a difference again between a properly structured LLC and just a run-of-the-mill standard LLC that people have these days. So that's the learning on that. Let's talk about rental properties. So for a lot of folks on the phone or on the call here, if we have people that have built their wealth through real estate, we have a large number of clients in our practice. That's where the wealth is coming from, is from a real estate portfolio. If that's you, this is important. So when we have a rental property here, as the Smiths do, they have one rental property. This rental property here is worth $500,000. Again, it's in the revocable living trust. So the question is, do we keep it or do we lose it? It's not the residence, so we don't get an exemption for anything. So we get no help that way. It's in the revocable living trust. It's toast. There's no protection from your revocable living trust. That thing is gone. What should a rental property owner do these days? First off, understand if you are a landlord and you're the one on title or your trust is in title and there's a lawsuit that happens at any of your properties, you're the one who's getting sued, right? It's not a company you've set up, it's you. And when they sue, they come after everything that you've got that's in your name. So we want to get away from that. We want to think of this as, if we're in the business of real estate, just like any other business, like a burger joint, or if we set up a construction business, whatever it is, if we're in the business, let's create an entity to protect our personal assets, not just hang out there as a sole proprietor in our name. So there should not be anybody left in that status where they're not holding their rental properties in LLCs. Had they done that prior to this incident, had they created a properly structured LLC to protect it, very different story. We limit the family that's suing to a charging order. They probably don't take it. We probably settle for a very small amount and walk away and keep our rental property. So that's one learning. The next thing is from a, just checking time here, I think we're okay. From a standpoint of, what if we have multiple rental properties? It's fairly common that we'll have clients who have 2, 3, 10, 20 or more, rental properties scattered across the US. What happens if we have one LLC and we throw all of our rental properties into that LLC and call it the ABC Rental Properties LLC? What happens there? Well, if we have a problem at one of the properties, here's the issue. We have a property, property A, let's call it, and let's say there's a major problem. The house burns down, the smoke alarm didn't work properly, and they blame the landlord. We've set everything up in a properly structured LLC. The problem is we have one LLC with a lot of properties inside of it. And to the extent that that's the scenario, the lawsuit can literally spread like a virus to all those other properties that are inside there. So we don't fix that problem. Ideally, we want to create a division between our properties. What is the magic number? Should we have a separate LLC for each of our rental properties? We would argue, yes, that's a good idea, but it's really a business decision, right? It's saying how much in terms of equity are we comfortable keeping in each box, and we plan accordingly. So had the Smiths here had, 4 different rental properties and they had, different valuations on them in terms of what they're worth, we could create 4 different LLCs to protect them as individual solos, or we could create 2 LLCs, put 2 in one, 2 in the other. But typically the learning here is more is better. The less assets in one box, the better off you're going to be. So that's the story on the rental property. What about the gold? So these over here on the left-hand side of the slide, we have 3 bars of gold. That represents bars of gold that the Smiths had bought prior to, all of this happening in the economy, the fear of, inflation, runaway inflation and so forth, and having some gold as a hedge there. They currently have that gold parked underneath their bed, and it's there just in case, of a meltdown. We value that gold at about $500,000. So quick poll question to see who's keeping up on this. In terms of the gold, we got this 500,000 in gold bars under the bed. Do we think that they will keep it? Do we think they're going to lose it? Do we say, what gold? And pretend it doesn't exist? What do we think? sorry, I lost it. There we go. All right, so 50% think we're going to lose it. The other 50% say what gold, which means we're doing a good job here. It means that we're now perjuring ourselves and the court and saying many of us think we're just not going to claim the gold. Here's the thing to know about this. When we're in this situation, it's a situation we pray to never begin. We never want to deal with this. This is just, if this happens and we end up in court, we find ourselves there. The process is we go through what's called a judgment debtor examination. And they're looking at everything that we have. And the lawyers are cross-examining you at that point on what do you have, what do you not have. Normally when lawyers are asking questions, they already have a pretty good idea of what the answer is. So if the question comes up, Mr. and Mrs. Smith, do you have gold? Do you currently own any gold? Chances are they know. Either it's shown up on a credit application somewhere, or they've got some way to substantiate that. If we lie at that point, we've committed perjury and we potentially go to jail. So not a good idea to lie about the gold. But what would be a very good idea would be if you look at that stocks, bonds, and cash LLC that we have created up at the top for the Smiths, that would hold the physical gold. We would put everything that we have, that's what we call a cold asset, our money in the bank, our investments, our assets that can't sue us, right? Not rental properties, not businesses, but just things that are cold assets. I'm not going to sue it. The hot asset is something that can sue you. We put those in the stocks, bonds, and cash LLC. We've now properly protected that. So it's not just easy for somebody to grab it and take it from us. So that's where that should be. From a 529 standpoint, I know we're kind of pushing up on time to get to the Q&A portion, but let's talk about that for a second. From a 529 standpoint, the Smiths here have about $200,000 that they're accumulating in their 529 plan for the kiddos, right? And so the idea is to save that in a tax efficient way. It's in the California plan, scholarship plan. Question here is, are they going to lose that as well? This isn't a direct asset of Jane's. This is more for the benefit of the kids. Every state treats this a little bit differently. And right now, the way California works, the answer is it depends. And it depends upon when assets were contributed to the 529 plan. So in the Smiths case, if they had contributed the assets to the 529 plan more than 2 years ago, it's 100% exempt asset. It's like the 401k. You can't touch it. You can't take it away. But for those assets that had been added within the last year or before, some degree of those would be used to satisfy the judgment. I believe if it's after a year that it's been in there, there's a $5,000 exemption. The rest is gone. If it's newly added money, it's gone. So from an asset protection standpoint, better if the 529 plan was moved to a state that does provide better asset protection. States like Nebraska, Alaska, they have great plans with great options inside of them, and they're fully asset protected in the event of a lawsuit. So not too hard to move those things if you have significant assets in the 529 plan. So that pretty much brings us, I think, around full circle on the Smiths. There's a lot of things that they could have done differently. And so they'd be a good candidate to have done some planning prior to an incident like this. But like I said, the issue could be anything. It doesn't have to be a car wreck. It can be, a lawsuit that happens at work, and how far does it spread? Could be somebody that you hire to fix the roof on your house, and you want to save some money, and they're not licensed, and somebody gets hurt doing something. We see all of it. So better to protect and take advantage of the laws that are there that can help you than to wait for something to happen and then figure out what happens next. In terms of talk on that, I think we've covered, guys, is there anything that we've left out here in terms of the areas that we want to touch on for this talk?
I think you covered it all. Yep.
So let's open it up and to some questions and see what we have out there in terms of questions that this might have brought up for people.
So a reminder, if you guys have any questions, use the Q&A box down at the bottom to ask any questions. And I do see a couple in here already. So one of the questions, it says, I have heard of asset protection trusts. Are these effective, and how do they work?
That's a good question. So we talked a lot today about one specific tool, the LLC, and that's a great first line of defense. Asset protection trusts there's different varieties of them. There's various different types of trusts that are out there, both revocable and irrevocable. Typical asset protection trust would be irrevocable. We're not allowed to set them up in California under California law, although many states allow an asset protection trust to be set up, Nevada being the one with the most established law. So we typically set up a Nevada-based trust to protect assets when we want to do that. And it's unique and it's different in that we have different sets of trustees that are in charge of that. For the scope of this call and the time that we have, we can't get too detailed in it, other than suffice it to say that if we have our stocks, bonds, and cash, our rental properties, a big bulk of our assets that are all held by LLCs that are then in turn owned by a Nevada Asset Protection Trust, and we roll that map out to somebody who's suing our clients and coming after their assets, it'll end right there. So that's the benefit. It's a huge deterrent from someone wanting to take your assets. It's a great tool. It's more expensive planning. So it really only makes sense when people have bigger assets to cover, or the situation is we have many clients who they've been sued before, they've lost everything, and they never want to go through that again. That's a great tool to use. There are also, offshore trusts, same variety of that, but we can move money offshore as well and go that route. Not very often do we see that, but we do have that happen in cases where people say, I want to make sure that doesn't happen to me. So yeah, definitely a good tool to use as long as it's set up and it's used properly. Let's see here. So I have some more questions that are coming in. Okay, so got a question here. Thanks for this one. It says, with an LLC, if the lawsuit comes from within the LLC, can they come after my personal assets? Is it different with an S corporation? Good question. So the first part of that question is, I've got the LLC. Let's say that I've got an LLC for my rental property, right? And it's set up, it owns that rental property, and there's a lawsuit that happens on the property, right? And it's a big lawsuit, and the amount of that rental isn't enough to satisfy the judgment like we had here with the Smiths. Question is, can they come after our house and our other assets anyway, even though it's in the LLC? What this comes down to is what I referred to earlier in terms of, is this a properly structured LLC, or is it not a properly structured LLC? In other words, will a judge allow the person who won in court to pierce that thing anyway and come after your stuff? That's a horrible situation, because you've done what you thought you needed to do and tried to protect it. You never want to see it get pierced and become irrelevant at that point. So the answer to that would be, as long as we have a properly structured LLC, in other words, we're created in a state, not California, where it's registered in California to be legal here. We've got a proper operating agreement. We're handling the LLC and treating it properly. In other words, we're not just commingling money all over the place and doing what we're supposed to be doing with it. Does a fantastic job, especially if it's a multi-member LLC, to stop that piercing. It's not going to happen. If it's not that, then all bets are off. If it's a single member LLC, just in California, you got it off the LegalZoom, your personal assets are still at risk. It's important to spend a couple $100 and fix that. The other question would be related to, I'm sorry, the second part of that I missed, and it's popped off my screen. Is an S Corp any different if that were to happen? Really, it's not any different, but with a properly structured S Corp, it's the same situation. As long as we're treating that properly, we set it up properly, we're doing what we're supposed to do with a corporation. We have formalities. We need to keep books and records. We need to keep minutes. As long as we're doing those things we're supposed to do, does a great job of protecting against that inside out issue that you bring up. So that's a good question. All right, so here's another question. What if a couple is not married, but they lived together for several years? Do the courts recognize them as a joint or married couple when being sued? Good question. So here's the first part to understand on that. It depends upon where the couple lives. So if we're in California, let's presume we're here in California. If we're here in California, there is no such thing as a common law marriage. Many people are under that misperception that I meet quite a bit, that, hey, we've been together more than 8 years, so the laws are just going to marry us, and now we're technically legally married and all the laws apply to a married couple. That's not how it works. So if that's the case in our state, from an asset protection standpoint, the court won't do that to you either. So if there's a lawsuit that happens and a couple is not legally married and one of the spouses is getting sued and the other one's not, it's almost like from a legal perspective that they are strangers in the lawsuit, and they can't just jump that over to the other person as if they were married. It's not a community property asset, and they haven't built any community at that point. So good question. Had they been married, different story. So that's when we want to do a postmarital. Okay, next question. Does an LLC formed in another state pay taxes in the state of California since the LLC is doing business in California? Ooh, that's a good one. So the answer to that is the franchise tax board here in California is extremely aggressive in this area. And their stance is, if we have an LLC in another state, let's take an example. Let's say we create an LLC in Nevada, and we create that thing because we have a property that's in Nevada. That's where the property is at. We live here, property's in Nevada. We create a Nevada LLC. Franchise tax board is going to say that you need to be registering that LLC in California because you are doing business in California. What does it mean to be doing business in California? From their perspective, that means that if you have well, here's the case. The way the case came down is we had a case, I believe it was in Utah, under that set of circumstances. And the question was, we had folks that weren't paying their $800 a year to California because they had set that up in Utah and they wanted to avoid it. The court came in and said, you're doing business in California. And they said, well, our landlord's in Utah, our buildings in Utah, our assets are in Utah, the bank account for the LLC is in Utah. What are you talking about? And the opinion was that if they had the question was, do you have the ability to hire and fire that landlord? And the answer to that is yes, we could fire them if we want to. There you go. You have control. Therefore, you have you satisfy the test at that point, and you need to be paying your taxes in California. So I guess the answer to that is yep. From an FTB standpoint, if you're an out-of-state LLC, that should be registered in California. Do a lot of people avoid that and not do it and run the risk of not getting caught, so to speak? A lot of people do. So it's really a judgment call on whether or not somebody wants to do that. But California, the FTB stance is you should be registered here and pay your $800 a year. Okay, time-wise, we may have time for another question. Let's see. I think we got into this one. Let's see. I own multiple rental properties. Should I have a unique LLC for each property or just one LLC to own all of the properties? It's really a judgment call. It really depends upon, your risk tolerance. Everybody's different. But from our perspective, we would prefer to have one box, one LLC for each property. That way we've limited liability that happens on any given property to just that spot and it can't spread. But really it depends upon, you do your own cost benefit analysis and you say, okay, what's the level that I'm comfortable with, knowing that, all this LLC talk is great, but there's a cost to it. And the cost is, like we just kind of alluded to, if you're in California, it's $800 a year, to keep that active in California. If you're using another state like Wyoming's going to hit you for $50 a year, which is, pretty minimal to borrow their state's protection. But when you go out of state, you have to have an out of state agent for service of process. They're going to cost about $100 a year. So all in, your carrying cost is maybe $1,000 a year per LLC that you have. That being the case, you have to weigh that against what's the value that I'm protecting with this thing. Is it worth it so I don't lose it? So it depends upon your risk tolerance there in terms of what you're trying to do. That's that. Let's see here. Okay. So I think, let's look and see if we have any other questions. I don't see anything here. Here's a question. So if my wife signed a quitclaim deed, can someone still take my properties? Kind of need to know a little bit more information on that. So if we have a property where, let's say it was the John and Jane example that we just went through, and Jane had signed a quitclaim deed prior to any of this happening and took her name off of title of those properties. If she's not on title and that all went down prior to the issue at hand that we're suing about, then we're safe at that point. She's not an owner of the property. It's not an asset of hers. And if she's the one getting sued, we don't have an issue here. But if we have the argument that comes back that that's a community property asset anyway, and the way that it's set up is we bring that back as community property, we still could have some potential for argument and issues there. So it would be wise to go to the level of beefing that up. In other words, create an LLC, make it properly structured. In all cases, it's just always better to be safe than sorry. We have a lot of folks that will do things to try to get around this. They'll try to take various people off of various properties, even though they're technically the owner. They'll hold property like in the brother's name, not their name. And a lot of that stuff doesn't work really well when we're called out on it. So better to do proper asset protection planning than that one. But yeah, generally speaking, that'll help if the person's not listed on the property. And time-wise, where are we at, guys? Is that about a wrap, or do we have time for more?
That is perfect. And in reality, I don't see any more in the question and answer. So I think you're good.
All right. Well, guys, I appreciate the time that you've given me today. I would be, at your disposal if you have, further questions that come up for you that you say, hey, I want to look at my personal situation. If you feel a little uncomfortable about any of the items that we talked about, you're human. You should. This is real stuff, and it's important to do planning while you can. So I build relationships with clients, all of my clients, as Adam said. So if you need help, by all means, reach out. And I think, Adam, you guys will have some info on how to do that.
Yep. Thank you so much, Brent. It's amazing what you do. I'm always surprised by the information you give and how easy you make it for us to understand. So for everyone, this concludes our webinar. You'll receive a link to the recording. The slides, there weren't too many slides, but you'll still receive those. And then Brent's contact information with some other helpful items emailed to you later today. Thank you for joining us, and have a great day. Thanks again, Brent.
Thanks. Appreciate it, guys.